couple things up here with you. One is we're scheduled for a probation violation hearing on an allegation that you were in possession of a controlled substance back last July and are facing charges for that, clonazepam. But then also I have signed a warrant that I'll arraign you on right now that you have violated your probation in a second incident. It's alleged that on or about April 1st, you were found to be in possession of methamphetamine, and also that you were subsequently charged with delivery or manufacture of methamphetamine. You do have the right to have a hearing on those allegations and the right to the assistance of your attorney. You're on probation to me for possession of methamphetamine, which is a felony carrying a maximum of 10 years and or $15,000 fine. So what I can do is schedule this then, now that we've arraigned you on the new one, probably schedule both of these violations for a hearing 2 weeks from today on April 23rd at 2:50 in the afternoon. Are you, when's your next court date in Alger County?
I'm not sure when. I was hoping to get the probation hold off and get bonded out so I can go to Jasper Mission Bible Training Center because they accepted my application.
Okay, well, I think for now, what I talked with the attorneys about is it's the probation officer who's not able to be here today. In the warrant says that your charge is delivery manufacture of methamphetamine. So we need to sort out what exact charges you're facing up there, whether it's a delivery manufacturer or possession or what's going on. So
it's actually a sales, I think it said.
Yeah, okay, don't tell me anything more about the situation, just if that's the charge. Okay. I would not be, under those circumstances, even with the possession, to be a close call, but I would not be removing my probation hold at this point. But we'll have a hearing in 2 weeks, and once we sort out what's going on, then we can figure out what we want to do about it. Okay.
Okay.
All right, but for now, I'm going to have you held without release. And we'll get an order up to Alger County so that they know that there's no bond on this matter and you're to be held without release. If they're not holding you up here, I guess then we'd have to go get you, but we'll let the jails sort that out. Anything further, Mr. Gill?
No, Your Honor, thank you.
Mr.
Can I say something?
Yes.
Just to let you know, on my probation, like I do have all my fines paid off and I was doing really good. I passed all my drug screens and everything up until just recently. Until this recent charges, I got, I slipped up, so I was hoping to get this hold off of here so I can go to Mission Bible Training Center and you might finish off my probation there.
Okay, I'm not going to allow that today. We're going to have a hearing in a couple weeks, but you're going to be held until then. All right.
Okay.
All right, have a good day.
Your Honor.
Is that Alicia Dockstader?
Yes.
All right, so this is People v. Dockstader, file 23-6661 FH, up for a probation violation hearing. And Mr. Gilbert, how are we proceeding today?
Your Honor, I believe she is going to admit that she's entered a plea in Presque Isle County.
All right.
I did meet with her this morning in the Presque Isle County jail.
All right, and I did take that plea. And so, Ms. Dockstader, do you understand that you've got the right to have a hearing on this violation?
Yes, Your Honor.
All right. And are you agreeing that I can take judicial notice of the plea that you entered in Presque Isle County?
Yes.
All right, so what I'll do then is I'll take judicial notice of the circuit's own records and find on a preponderance of the evidence that the violation has been established. Any objection to that, Mr. Gilbert?
Not at all, Your Honor. Thank you.
Ms. Who's handling this one?
I'm
Ms.
Your Honor,
Any
please
objection
go
to
ahead.
that process?
No, no.
All right, and so what we'll do is, do you know when I set the sentencing date for over there?
I'm not her attorney over there.
Oh, yeah, I'm sorry. Ms. Dockstader, do you know what your sentencing date is in Presque Isle County?
It is April 22nd.
Okay. Well, this is a probation one, so why don't we do this one on April 23rd and see if they can get the report out soon enough. So let's schedule this for April 23rd at 2:10 in the afternoon. Anything further, Mr. Gilbert?
No, Your Honor, thank you.
Ms. Miller?
Oh, Your Honor, thank you.
Okay, so Ms. Doxtater, I'll see you on Monday, April 22nd in Presque Isle County, and then Tuesday, April 23rd at 2:10 here in Sheboygan County.
Thank you, Your Honor.
All right, you have a great day.
You too.
All right, Mr. Smith, would you please stand and as best you can raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can be seated, sir. Is your name Cody Addison Smith?
Yes.
All right, and Mr. Smith, in a no contest plea, I won't ask you about what happened. I'll review this affidavit. It's been marked as joint exhibit. But I will ask you a lot of questions just to make sure that you understand what's going on and that I can answer any questions that you have. So my first question is, do you understand that a no contest plea has the same effect as a guilty plea in terms of you being convicted of the offenses, my authority or jurisdiction to sentence you? Do you
Yes.
understand? All right, and for that reason, it's an important hearing and you waive rights by entering a plea. So listen carefully. If you have a question, ask me. If you need to talk to your attorney some more, just let me know. Now, in both these files, you're pleading no contest to domestic violence, third offense. And that is that's a felony punishable by up to 5 years and or a $5,000 fine. And with one of them being committed while you were on bond for the other, it would be discretionary consecutive sentencing, meaning the maximum penalty that you could face by law would be 10 years in prison. Do you understand that?
Yes.
All right. Did you read and understand the rights listed on the advice of rights form?
Yes.
And you signed that form?
Yes, sir.
Do you understand this lists the rights that you give up when you enter a plea?
Yes.
Do you have any question about any of those rights?
No, I do not.
Do you wish to waive those rights and enter a plea according to this agreement?
Yes.
Now, if I accept your plea, you can't come back later and tell me that it wasn't your own free choice for any reason, including threats made to you or promises outside the terms of the agreement. Do you understand that?
Yes.
All right. Now, also, when you plead no contest, you lose the right to appeal. If you wanted to appeal later on, you have to seek permission by filing an application. And the types of issues you could raise on appeal are very limited, much more limited than if you were convicted after a trial. Do you understand this?
Yes, I do.
All right, now the plea agreement provides in exchange for your plea of no contest to one count in each file of domestic violence third offense. The prosecutor will dismiss the remaining charges. There's any weapons seized to be forfeited in the agency that seized them. And there's a sentence agreement for a county jail cap with concurrent sentencing. Do you understand the terms of that plea agreement?
Yes, I do.
Mr. Clean, is that a full, fair, and accurate statement of his terms?
Yes, sir.
Ms. Goodrich?
Yes.
All right, Mr. Smith, that sentence agreement is not binding on me. If I don't want to follow it, I wouldn't have to. But if I did not follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yes.
Now, that is unless you do something else wrong between now and the sentencing. If you don't show up for court, you violate your bond, or you commit a new crime, something like that, then your misconduct would mean I don't have to follow the agreement, but you would have lost your right to withdraw the plea. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead no contest?
No, they have not.
Has anybody threatened you?
No.
Is it your own free choice to enter that plea?
Yes, it is.
Knowing all this, then, how do you wish to plead in file 23-6593, the charge of domestic violence third offense? Guilty, not guilty, or no contest?
No contest.
And how do you wish to plead to the charge in file 23-6639 to the charge of domestic violence third offense? Guilty, not guilty, or no contest?
No contest.
All right, and I have reviewed what's been marked as joint exhibit 1, and I do believe it establishes a factual basis for both files for domestic violence and also the affidavit lists of prior in 2021, but also, Mr. Smith, did you have a prior domestic abuse conviction from that was the 2021. Did you have a prior one from 2008?
Not that I can recall, sir.
You did the third offense notice, Mr. Cleon lists a 2022 domestic abuse and a 2008 assault conviction.
Yes. Just confirm that. I believe those were the predicate priors.
Okay, Mr. Smith, did you have a conviction for an assaultive crime in 2008?
If I did, I do not recall what it was for.
This was good.
It doesn't really give me much information, Ms. Goodrich, in the offense notes. What was that?
That's, in seeing the, I guess, with the record conviction, that does refresh Mr. Smith's memory of a sentence we gave 2009.
All right, so Mr. Smith, you don't contest that you've got two prior assaultive convictions that makes this a third offense, do you?
No, sir.
All right, Mr. Clean, you satisfied with the factual basis?
I am.
Ms. Goodrich?
Yes.
And Mr. Clean, are you aware of any other promises that are due?
I'm not,
Ms. Goodrich? Mr. Clean, do you believe I complied with 6.302?
or has.
Ms. Goodrich?
Yes.
All right, Mr. Smith, I found that your pleas are knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I'll accept your plea to both files. I could schedule sentencing for the 14th at 1:10 in the afternoon. And Mr. Smith, you'll have to cooperate with an interview with the probation department so they can write a report for me before the sentencing. And Mr. Clean can give you some more information about helping you make that connection. And Mr. Clean, did you have a request?
I did, Your Honor. With regards to bond in these two cases, the court is aware there's a sentence agreement for 1 year of incarceration concurrent. Mr. Smith has served 15 months in pretrial incarceration. So well in excess of the agreed upon amount. Mr. Smith's plan is to go back to Wisconsin where he has lived with his father. So I'm making two requests. First, that bond be set as a personal bond with the provision that he go to Wisconsin and stay there. And secondly, that he'd be allowed to leave the state. And we're also making the request that on the 14th, if there's no need for further incarceration or no reason the court would call a sentence agreement, that Mr. Smith be allowed to appear for that hearing by Zoom.
All right, Ms. Goodrich, on behalf of the people.
However, the victim supports that request for his release, and it would benefit her and children to get some financial support from the defendant. On behalf of the people, I support the request. I think it'd be very helpful to see his behavior between now and sentencing in order to determine the appropriate sentence.
All right, well, Mr. Smith, I think, and now I've reviewed some of the more facts of the case as well, and the sentence agreement and the time that you have already served. I'm going to enter a personal recognizance bond, $5,000 in both files. You don't have to post that amount. That's the amount you'd have to pay as a penalty if you don't appear. And the conditions will be that you are allowed to leave the state to go to Wisconsin, and we're going to expect that you do. And well, I don't think I can make that a condition of bond. I mean,
It's not a condition of bond.
banishment is not a valid.
Is that, I'm not asking to be banished from the state of
We're going to
Michigan.
allow him to, we're going to allow you to go to Wisconsin. And it'll be standard conditions along with the special condition of no contact with the victim. And I will allow Mr. Smith to appear by Zoom for that sentencing if he waives his right to be personally present. So Mr. Smith, you would have the right to be personally present for your sentencing on a felony case. If you want to waive that and appear by video from Wisconsin for that sentencing, I'm okay with that. Are you okay with that?
Yes, I am.
All right. Now that's conditioned on you making sure you get that interview done with the probation department. Okay.
Okay.
All right. All right. We'll see you then. H. Nancy, you want to state your address, please?
Jeremiah Buffalo on behalf of Mr. Love, who is seated to my right.
All right, and have you had a chance to review the updated PSI
Yes, Your Honor, I have.
additions or corrections today?
Yes, Your Honor. We would add that, correct, Mr. Love has completed the assessment. There was a hiccup with them not releasing it due to his inability to pay. We have very recently since forwarded that to the probation department. There in that assessment were no requirements for any sort of counseling or anything like that that he would have failed to do. And he has made payments on his fines and costs as well since the issuing of that PSI, Your Honor. I believe there's only approximately $70. $40 that are remaining. Your Honor, we would ask for a very brief adjournment to allow for those things to catch up with Mr. Love's file and potentially have him successfully complete his delay of sentence.
Well, I had the assessment dated March 25th of 2024. Is that the one you're talking about?
Yes, Your Honor, it is.
So completed after the PSI. And I don't know what you mean it doesn't make any recommendations. It says recommendation are related to individual and group counseling related to emotional regulation, skill development, interpersonal skill interactions, problem solving skills, vocational and aptitudes, career planning, exploration assessment, as well as financial literacy. That doesn't sound like no recommendation to me.
I missed that, Your Honor.
All right, Mr. Love, you don't have to make a statement today. Is there anything you want to say?
Yes, sir. So
Go ahead and stand up.
yes, so I was unaware that I had to follow anything when I talked to the assessment people. They were,
Did you read this assessment?
I actually asked for mines to send it to me, and they told me that I wasn't allowed to receive it, that only my probation officer can have it. And when I did the assessment, they never told me, hey, you have to do these things, you know, and I called, I went up there twice, and they just said, congratulations and good luck, basically.
Mr. Love, can I ask you, what did you do that I asked you to do during this last year? Did you get a job?
Yes, sir.
When?
I got a job just recently. I was working at, well, I mean, more than just recently. I worked a few months before that. I worked at McDonald's. I worked with a couple staffing agencies. Your Honor, it's been very hard for me to grab a job with this felony. I know that you want me to hold on to a job, and by nature, that's how I am. That's what I was doing before this even happened. But because of the nature of the felony on my record, I keep getting denied jobs. So only thing that I'm even getting denied jobs in staffing agencies, but I've had held on to a couple jobs. Right now, I'm with a staffing agency, but laid off because it was only a 2-week employment for a line that they had to catch up on, and then they laid me off. And I've been waiting and waiting because that's all I really want to do, Your Honor. I just want to get this passed so I can start working and get my life back.
If I may, Your Honor, is the court in possession of the email from the probation officer downstate, Mr. Secor, that indicates that he has, that Mr. Love has had employment on and off?
No, I got
Again,
the
it was-
census report.
It was fairly recently that the email was received and forwarded to your probation department. And like this morning recently, Your Honor.
Well, I got the pre-sentence report, and I got the assessment that makes recommendations. If there's an email you want me to read, somebody better give it to me.
I don't have the hard copy here, Your Honor.
All right, Mr. Rich, Mr. Juliet, any recommendations for the people?
Your Honor, I would ask that the delay be revoked, and probation be discharged unsuccessful, 6 months in jail. I would note for the court that back when he was sentenced on the delay, the court waived a number of costs. So the fact that he hasn't completed his financial obligations is concerning. And in his allocution, I guess he did say that he's had jobs, but they've been on and off. So that's concerning that he can't keep employment, not so much that he can't get employment. So I guess I would ask that the delay be revoked and count one penner.
All right, well, Mr. Love, you're here today after a 1-year delay of sentence for a felony crime of resisting or assaulting, obstructing police. I gave you a lot of consideration a year ago and didn't ask you to do a whole lot. And you did even less than I asked. You know, you didn't maintain employment, and the excuses you're giving me here today are pretty weak. There's a lot of people with worse records than you that are able to maintain work. And also, I cut your fines down about as low as I possibly could. In fact, I did, the lowest I could legally assess. And you didn't pay them in a year. And these were doable. These were doable if you were picking up cans. Plus, you were supposed to get an assessment. You don't do that until like a couple weeks ago. And then you're here today telling me, and I don't have to do anything with it, but I'm reading a bunch of stuff that you have to do to address the issues that brought you before the court. And you should have done those is a year ago. That's why we put you on a delay for a year, so that you can do this on the front end and go to counseling and get in a better spot. Not so you can come once you find out you're in trouble and then you go and get one. That is not how that works on you. I can't possibly find that you have successfully completed this delay. So, Mr. Love, you have not successfully completed the delay, so we do have to sentence you on the underlying offense. The felony conviction for resisting, obstructing police will enter. The guidelines are 0 to 9 months. And I'm going to order that you serve 3 months in the Sheboygan County Jail, give you credit for 3 days previously. That's within the guidelines. And if you want to appeal, you have to file an application with the Court of Appeals. If you want a lawyer, you have to ask within 42 days. Any amounts that are unpaid will remain due and owing on the judgments. Good luck to you, Mr. Love. I cut the sentence even in half what was recommended. Mr. Love, I've done all I can and will do for you right this instant. Or you're gonna go for longer. If you want to go for longer, then keep it up. Right now. Exit my courtroom, sir.